So here is Judge.
Yes, I can hear you. Can you hear me okay?
Yes, sir.
All right, Mr. Gamble, are you ready to proceed, sir?
We are, Your Honor.
Is this Mr. Ryan Higgins?
It is.
All right, this is cause number CR 23-128, CR 23-129, State versus Ryan Matthew Higgins. Mr. Higgins, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, nothing but the truth, so help you God?
I do, Your Honor.
All right, you can lower your hand. Make sure you speak up loudly and clearly. Mr. Gamble, is this a plea today?
It is, Your Honor. We were set for a plea, and I understand there's a requirement for a PSI to be conducted.
Yes, that is a new procedure that the court has started with the DA's office. So do we want to set this for a plea then and order the PSI?
We can, and Mr. Hartwell and I spoke this morning. He agreed to a short form PSI.
Okay.
And we can set this for a plea at the next available setting.
Well, I'm gonna have time for the probation department to do that PSI. So it's probably gonna be a 30-day reset.
And Your Honor, in the meantime, state is in agreement with a PR bond. Since this is going to be a probation offer, the state would be in agreement with that.
Okay. All right, then if you got your calendar, Mr. Gamble, I've been setting in August to give the probation department time. I'm trying to give them at least 30 to 45 days to fill all of the PSIs that have been coming their way. So I'm looking at August 8th, August 10th of that week, if one day is better than the other.
August 10th looks to be open, Your Honor.
Okay, we'll set Mr. Higgins in for plea August 10th. That'll be we'll set that at 9 a.m., Mr. Higgins, anticipating that you'll still be on bond. Court finds that the parties have agreed to a personal bond. In each matter, the court will approve the agreed personal bond, and you're going to have conditions of pretrial release, Mr. Higgins. It's going to require you to have interlock device on your vehicle, things of that nature. So you're going to have to sign those conditions before you're released, and I'll have all that paperwork sent out to the jail.
Yes, sir.
All right. We'll see you back on August 10th at 9 a.m. in the courtroom.
Yes, Your Honor. Thank you, Your Honor. That is all I have today. Can I be excused?
Yes, sir. Thank you, Mr. Gilmore. Is there a reason I'm trying to log in over there?
Your Honor, Mr. Harden is ready on his plea on John Davis that was going into custody for safety.
They're having problems with the internet. This is backup because that one and then she'd be able to use this.
Okay. All right. This is John Robert Davis, CR 2155. All right, let's see. It appears that there's an agreement in this case. The state has indicated it wants to withdraw its motion to adjudicate, extend Mr. Davis's probationary period for an additional 1 year, and require him to attend the substance abuse felony punishment facility as a condition of community supervision. Is that correct, Mr. Harden?
It is, Your Honor.
All right, and Mr. Hartwell, that's the state's agreement. Is that correct?
It is, Your Honor.
All right, Mr. Davis, if you'll raise your right hand, I'm going to place you under oath. Mr. Davis, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Sir.
All right, you can lower your hand. All right, Mr. Davis, so you heard what I announced as your agreement with the state. Is that correct? And you understand that if the court approves this, your probationary period will be extended an additional 1 year. You'll go into custody today and you'll await a bed at the Safe P facility. You understand that?
Yes, sir.
And are you wanting to go to Safe P? Are you wanting to get help with your drug problem?
I don't want to go to safety. No. I don't, but yes, I do.
You understand that by telling me you don't want to go gives me concern that you're not going to go down there with an open mind and try to get help for your issues. What I don't want to do is send people down there that don't want to go, because it's a waste of resources and it's a waste of bed for someone in another part of the state that may actually need it. So I need to know, if you're just going to Safe P to avoid prison, that's the wrong reason, completely wrong reason.
Have you heard on the issue, Judge?
Please.
His wife died not long ago. And then his children, who he and his wife had primary custody of, were taken by the father, the natural father of two of the three children, and removed from the state of Texas. And that's been a problem for him. And his concern about the children is the reason he's concerned about going to Safe P. And there's also potential of him having to fight to keep the home that he had his children in until they were removed by the terminated parent to the state of Louisiana. And so that's the reason that he's sort of recalcitrant, but he is willing to go, Judge. He understands he needs help.
Is that correct, Mr. Davis?
Sir.
I understand if hard times have fallen on you, I'm sorry for that, but you understand that the issue I'm faced with is whether or not you're going to seek to reform your drug or alcohol issues. You understand that? All right. Mr. Davis, has anyone threatened, forced, or pressured you to enter into this agreement?
No, sir.
Are you pleased with Mr. Harden and the services that he's rendered to you?
Sir.
And Mr. Harden, you've explained to Mr. Davis the consequences of this agreement regarding the extension, the confinement as part of safety. You've relayed all that to him, and you believe that he's entering into this agreement intentionally, knowingly, and voluntarily, correct?
Yes, Your Honor. I've explained to him that 6 months to 1 year, then 90 days weekly report, intensive outpatient, and then bi-weekly for the following 90 days. And then the remainder of the probationary period, standard probation after that.
All right, thank you, Mr. Harden. All right, the court's going to find that after admonishing Mr. Davis, he's aware of the consequences of his plea, that he's entered into this intentionally, knowingly, and voluntarily. Court will grant the state's motion to withdraw, the motion to adjudicate. Court hereby extends the probationary period of Mr. Davis for an additional 1 year, amends his conditions of community supervision to include substance abuse felony punishment facility as a condition. The court hereby extending that order and adding that condition of community supervision grants the withdrawal of the state's motion to adjudicate. All right, so there's nothing more on paperwork. Mr. Davis will be taken into custody and he'll remain there until a bed becomes available.
Yes, Your Honor.
Thank you, Mr. Harden.
Have you excused him?
Yes, sir.
Hey, Your Honor, we are ready on Jordan Manus.
Is there a lawyer? So I
Yes, Your Honor.
Not much of one, but there's one.
Not much of one, but there is one. That's a good one. How are you, Mr. Cassell?
I'm good, Judge.
All right, this is cause number CR 20-397, State versus Jordan Wyatt Manus on motion to revoke. Got any announcements for me, sir?
Yes, Judge, if we could get some more time. I've been in a capital trial last week and hadn't had any additional time to talk to Ms. Curry. I know we spoke a couple weeks ago and just need some additional time to follow up with her on a few issues.
Okay, I'll tell you what we'll do. I will set this for the contested docket on July 25th. That'll give you roughly 30 days to see if y'all can reach an agreement. And then if there is an agreement in something that's dispositive that we need to hear before that, I have a couple docket settings that we can take those up on. If there is no agreement, no resolution, then we could just move forward with a contested hearing on the 25th.
And what time would that be?
As long as Mr. Manus is in custody, then it'll be at 1:30, but on the evidentiary hearings, it will be here at the courthouse, in person on those top hearings.
Okay, all right, sounds good.
All right, we'll see everyone back on July 25th at 1:30, and it's good to see you.
Thank you, Your Honor. Good to see you.
Anyone else ready?
Mr. Manus, wait.
I'll call you back.
They need something. They need something on this guy. They don't know. So I can give it a copy of this. Yeah, it's not mine. It'll be just a moment, Judge.
Okay.
All right.
Yes, sir.
Mr. Manning, who are you ready on?
Judge, ready on our writ for Mr. John Johnston.
All right, this is writ WR 23-49. Mr. Johnson, will you be calling your client today as a witness?
Judge, we'll just rest on our motion. He is, as my motion says, was arrested on March 23rd, 2023 on an aggravated assault with a deadly weapon. That bond is set at $75,000. He's been continuously detained in Van Dent County since March 23rd. And so we're past our 9 days. The state is not ready for trial.
Agreed, Your Honor.
All right, can the state relay do you have any information about criminal history or anything that court needs to be aware of as imposition of conditions of bond or anything? Senate Bill 6 has changed the landscape on judges' liability for things regarding personal bonds and safety to communities, or any information the state can give me?
Yes, Your Honor. With regard to criminal history, Judge, it appears that the defendant has a prior possession of marijuana from 2009 for which he served 45 days, and that is his only criminal history.
Okay. And I don't know, I can't tell by the writs, because I don't have the writ in front of me. I don't think I do. Let me see, Mr. Manny, did you put in the writ what he's accused of, if it's a crime of violence, if there's an alleged victim, anything of that nature?
Yes, Judge. In the writ, it contains the offense to which she's being held. As I said before, that is aggravated assault with a deadly weapon.
It appears, Judge, that the victim is a man named Justin Lee Wakeham, Wakeham.
Okay. And it looks like I've already signed conditions of pretrial release to Mr. Johnston, should he be put on bail. And I do have victim protection in there as paragraph number 4. So, all right, I appreciate the information. The court will grant the writ, find that it is agreed by the state. The court will order a personal bond of $75,000 for Mr. Johnston on the charge of aggravated assault with a deadly weapon. And the court has entered conditions of pretrial release. Mr. Johnston must sign those conditions prior to being released from custody. I'll have that order and those conditions sent over to the jail.
And Judge, also, if maybe I maybe copied on those orders from my files as well. I haven't been getting all the orders that have been signed on these writs, so if I could be copied on that as well, I appreciate it.
Will do. Who are you ready on next?
Judge, ready on our writ for Mr. Michael Huddleston.
Your Honor, if I could have just a moment on that one, we do have a witness on that, writ. I don't believe he has arrived yet. That's my fault. I told the witness that the court would go through the docket and we would have the contested hearings at the end. So he's supposed to be here about 2:15.
Okay, all right. Have a seat and we'll recall your case. We have any other attorneys that are ready?
Yes, Your Honor.
Yes, yes.
Jay Wheeler with, Mr. Bath.
Good afternoon, Judge.
Good afternoon, sir. How are you?
Very well, thank you.
Let me get over here to your case real quick. All right, this is cause number CR 23-22, State versus Jake Emil Wheeler on pretrial. Mr. Bass, have you received all of the state's discovery? Are there any pretrial issues we have to take up?
I did what I had on the last, on the last reset here, items if needed. And I did read in the meantime, there was apparently an attempt from the FBI to interview. Now, I don't believe Mr. Wheeler told them anything, but just to be on the safe side, I'd like to get a copy of that. But that's the only thing we need, looks like to me.
So,
If such,
go ahead.
if such,
Hang on, Ms.
I'm
Craig.
sorry.
So go ahead and identify exactly what it is. It's an alleged FBI interview of your client on what date?
I'd have to look at the report again, but I'm not sure it has a date, but they did say that FBI agent came over and attempted to interview, and Mr. Wheeler, I don't believe said much of anything, but as I say, just to be on the safe side, I'd like to take a look at that if they reported it or they make a record of it in some fashion.
All right, thank you, Mr. Bass. Ms. Curry, go ahead. Sorry to interrupt you.
Sorry, Judge. If in fact that occurred, the FBI has not provided the video to us, will not provide the video to us, and we have no subpoena power to get it.
Okay, so you're telling Mr. Bass that the state will not be using any such evidence because you don't have it and don't have access to it, nor can you get it.
Correct.
Mr. Bass, any response?
Well, if it's a statement, I think I got a right to get it, but I said there may be not much of anything there, but it seemed like if the FBI would provide that to the district attorney upon request.
It is not in the possession of the state of Texas. If it is a statement, if there is a statement, it is not in the possession of the state of Texas. The FBI routinely and repeatedly refuses to share information. We have no access, no ability to get it.
Mr. Bass?
Well, I'm still requesting it, Judge, and I'd be up to the court on the ruling, but I believe we have a right to have any kind of statement that Mr. Wheeler made.
It's in the possession of the,
Government agency.
But you don't know, Mr. Bass, that he made a statement.
It refers to it in the report, and it doesn't say that he gave information, but they attempted to get a statement. And whatever he said, I think I got a right to have it. He said, I'm not making a statement, or I don't want to make a statement, or I didn't do anything wrong, or exactly what he said to him. I don't know.
Okay, and your client
neither
can't
do I.
and your client can't relay that information to you.
He probably could, but there again, if that's in the possession of the government, I don't know, it might be helpful to the defense of the case, whatever they have.
But what I hear Ms. Curry saying is it's not in the possession of the state of Texas, and so they can't use that. They can't use that against Mr. Wheeler in his trial, and they don't intend to because they don't have it.
If that's court's ruling, I understand, Judge.
So what I would anticipate is if this issue pops up later and the state all of a sudden has it, then it would be ground for a motion to suppress. I could order it turned over and then I could suppress it if it was prejudicial to your client.
understand. I understand, Judge.
Ms. Curry, any issue with that? Ms. Curry? I'm sorry, we may have lost you for a second there. Did you hear me? Do you have any objection to what the court stated to Mr. Bass, if you heard that, is that if it's not in your possession and later it comes in your possession, that I could order you to turn that over as you would in compliance with the court standing order in criminal cases. And if it was prejudicial to his client, later then the court could suppress that if it's not been provided.
Yes, Your Honor, I don't anticipate that if there is such a statement, there are any circumstances that would cause it to come into the possession of the state. We do not have it now, but I would point out for the court that 3914 is specifically limited to items that are in the custody or control of the state or any person under contract with the state. And the FBI is certainly not under contract with the state of Texas. I have no way to force them to give that to me. If it were later in some method to be provided to us, then I would immediately make it available to Mr. Bass. And depending upon how immediate I was, my intention would certainly be the same day to do it. If there was an unreasonable delay, then I could certainly understand it being suppressed at that point. But I think discovery in any context is a continuing duty. And just because I don't have it today, there may be other items of discovery that come into our possession after today. And I think that in that particular instance, the court's duty then is to determine the immediacy of our making that available and turning it over to the defense.
Mr. Bass, any response?
No response to it, Judge. Thank you.
Okay. All right. Are there any other issues on pretrial other than that possible statement?
Judge, I filed a pretrial motion suppressed, and look based on it, it's not dispositive of the case, but I'm sure the court would want to carry it along with the trial. I'm just alerting the court that that's filed.
What is it that you're specifically looking to suppress?
It'll be statements made at the time of the initial interview and arrest of Mr. Wheeler.
And that's on the basis of no reasonable suspicion or lack of probable cause?
And no Miranda on part of it.
Okay. So what I would do is I would go ahead and set your pretrial motion for hearing so that we don't carry it with the case, so that we have a ruling on that and we're not delaying a jury trial to have a motion to suppress hearing at the time of trial, which could affect the ability for both the state and the defense to prepare. So what I can do, Mr. Bass, is I can set you for a contested hearing on July 25th, and you can argue that motion and then the court can rule on that.
All right, fair enough. Thank you.
Okay. And Mr. Bass, does your motion, I haven't reviewed it, but does your motion specifically lay out the alleged illegality that led to the procurement of statements or evidence, or is it just a general boilerplate?
It's general boilerplate, Judge.
All right, so typically what I do is I deny those. I just deny those until they are drafted with specificity to put the state on notice, so that we can make sure that we use judicial time and resources and it's not a fishing expedition. So do you want me to go ahead and set it, and you're going to, as an officer of the court, tell me that you're going to refile that motion, allege specifically what your issues are, so that we can take that up?
That'd be fine, Judge.
Okay. All right. Court's going to set the motion to suppress for hearing on Tuesday, July 25th. That'll be at 1:30 in the afternoon. And then I would direct you to file that as soon as possible, but of course, no later than at least 10 days before that hearing on the 25th.
Judge Good, is that going to be at the courthouse?
Yes, sir. Yes, sir. That's a good question. It will be at the courthouse, and I'll have Mr. Wheeler brought over for for these type of contested evidentiary hearings.
Okay, great.
All right, we'll see you back on July 25th at 1:30 at the courthouse.
Thanks, Judge.
You're welcome.
Okay, Your Honor, we're ready on O'Brien Colquitt's plea. And Michael Smith. Which one? Michael Smith.
All right, this is cause number CR 22-320, State versus O'Brien, Tyree Colquitt.
Mr. Smith, Judge, I can get Colquitt up here if you want.
Oh, I'm sorry, I thought Ms. Taberham said Colquitt.
I did a bait and switch. I'll get Mr. Colquitt. Come up here.
Okay, please. All right, yeah, back up a little bit. Yeah, I won't be able to see you there, Mr. Colquitt. All right, you are O'Brien Tyree Colquitt, is that correct?
Yes, sir.
All right, Mr. Is that how you say your last name, Colquitt?
Yes, sir.
If you'll raise your right hand, sir, I'm going to place you under oath. Mr. Colquitt, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, thank you. Lower your hand. Just make sure that you continue to speak up loudly and clearly so I can hear you, so my court reporter can take down what you have to say, okay?
Yes, sir.
Mr. Colquitt, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
You're represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt and the services that he's done on your behalf?
Yes, sir.
Do you feel like you've had enough time to talk to him about the plea agreement and that you understand everything that you have read and signed in this plea agreement?
Yes, sir.
Mr. Schmidt, do you believe that your client is competent, that he understands the consequences of the plea, and that he is entering into these intentionally, knowingly, and voluntarily?
Yes, sir.
All right, Mr. Colquitt, you are charged by indictment with a third-degree felony offense of evading arrest or detention with a vehicle that does carry a range of punishment of not less than 2 years in prison or more than 10 years in prison, and also carries a possible fine not to exceed $10,000. I see the plea agreement in your case is that you would plead guilty to that charge. In response, the state would be recommending that your punishment be assessed at 3 years confinement in the Texas Department of Criminal Justice. They are further recommending that your sentence be suspended and you being placed on community supervision or probation for 3 years with a $1,000 fine, $290 in court cost, $585 in reimbursement fees. Mr. Colquitt, is that your understanding of the plea agreement and what you're asking the court to approve?
Yes, sir. Yes, sir.
All right. All right. Then, Mr. Colquitt, how do you plead to that offense?
You.
Are you pleading guilty to that crime because you are guilty of committing that crime and for no other reason?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty?
No, sir.
All right, the court does accept the defendant's plea of guilt. Mr. Schmidt, any objection to the state's evidence supporting the plea?
No objection.
All right, states one is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor.
Oh, you're on.
Anything further from the defense?
Nothing further.
All right, court is going to review the evidence briefly. All right, the court has reviewed the evidence. Court finds sufficient evidence to convict the defendant of this offense. The court will follow the plea agreement in this case. The court convicts O'Brien Tyree Colquitt of evading arrest or detention with a vehicle, assesses his punishment at 3 years confinement in the Texas Department of Criminal Justice. The court suspends that sentence, places him on community supervision for 3 years, orders him to pay a $1,000 fine, $290 court costs, and $585 in reimbursement fees. Mr. Colquitt, you're hereby remanded to the custody of the probation department. so they can carry out the terms and conditions of the sentence. I'm gonna have you step over with the deputy to be fingerprinted, after which the probation officers will give you more information.
Straight out.
All right, is this Michael Smith?
Is
All right, this is cause number CR 20-227 State versus Michael Wayne Smith. And I believe this is a writ seeking bail reduction. Is that correct?
Judge, we've got plea papers in front of us ready to proceed.
Oh, okay. Can you tell me the? Oh,
Yes.
actually, here, that's okay, Mr. Schmidt. I found them. All right, Mr. Smith, raise your right hand. I'm going to place you under oath. Mr. Smith, do you swear that the testimony you give to the court will be the truth, the whole truth, nothing but the truth, so help you God?
Sure.
All right. You can lower your hand. Make sure you speak up loudly and clearly for me. Mr. Smith, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
You ever been diagnosed with a mental condition?
Yes, sir.
You're represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt and the work he's done for you?
Very.
Do you understand all of the paperwork that you've read and signed today?
Sir.
You feel like you've had enough time to go over that with Mr. Schmidt and have all of your legal questions answered?
Yes, sir.
Mr. Schmidt, do you believe your client to be competent and that he understands the advantages and disadvantages of a deferred adjudication plea and that he is intentionally, knowingly, and voluntarily entering into this plea?
I do, to all counts.
Mr. Smith, you are charged by indictment with a third-degree felony offense of possession of a controlled substance in penalty group 1, greater than 1 gram, less than 4 grams. That does have a range of punishment if you were to be convicted and sentenced. The sentence must be within the minimum 2 years all the way to the maximum 10 years and carry a possible fine of not more than $10,000. I see that the plea agreement is you would plead guilty to that crime. The state's recommending that you not be convicted, that you be placed on deferred community supervision for 3 years, and that you pay fine, court costs, restitution, and reimbursement fees. Is that your understanding as well, Mr. Smith?
Yes, sir.
All right. Understanding the plea agreement, understanding the range of punishment, Mr. Smith, how do you plead to possession of a controlled substance in penalty group 1, greater than 1 gram, less than 4 grams?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty?
No, sir.
The court does accept the defendant's plea of guilt. Mr. Schmidt, any objection to states 1?
No objection.
All right, states 1 is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor.
All right, anything further from the defense?
No further, Judge.
All right, court's going to review the evidence. All right, the court has reviewed the evidence, finds that there is sufficient evidence to convict Mr. Smith of this offense. Court will follow the plea agreement. Court defers the finding of guilt, places Mr. Smith on 3 years deferred community supervision, orders him to pay a $1,000 fine, $180 restitution, $290 court cost, and $585 in reimbursement fees. Mr. Smith, you hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. Please step over with the deputy to be fingerprinted, after which the probation officers will give you more information. All right, Mr. Manning, you ready?
Judge, I'm unsure as to the status of, I've been in negotiations with Ms. Curry. And I think we may have a resolution so that we don't have to go forward on this writ.
Okay, remind me who the writ was on.
This is on Mr. Huddleston.
Huddleston? Ms. Curry,
Yes, sir.
did you have a response to Mr. Manning?
I can't hear Mr. Graham.
Mr. Manning, can you state what you said earlier?
Yes, Judge. I was just announcing to the court that I think we may have with reason to withdraw our writ at this time and set this for a pre-indictment plea.
That is correct, Your Honor.
Okay. All right, then how long do you need? Do we need a PSI on this?
Yes, Your Honor.
Okay. All right, court will, do you want to reset your writ? Do you want to withdraw it and dismiss it? Do you want to, what do you want to do on that, Mr. Manning?
Well, judges, I think that's going to depend on when we can get him set. If it's going to be beyond the 90 days, then I'd ask that we hold that writ in abatement. If it is going to be prior to that 90 days, then I don't mind withdrawing and dismissing.
I'm not sure when your 90 days is going to be, but it's going to be in August before the probation department will have time to meet with him, do the PSI, prepare the reports and send it to the parties. So I was going to set it August 10th.
Judge, let me speak to my client just momentarily.
Okay.
Judge, if we may, we'll hold that writ in abatement. But if we can be set for the earliest possible date for him to plead, like I said, this is going to be for a probation plea. If we can get that as done as soon as possible, I believe that would be in the best interest of all involved.
Okay. Court can set it for August 10th for a plea, and then order the PSI. And Ms. Curry, would this be a short PSI or a long?
Judge, it should probably be a long form.
Okay. All right, court will hold the, will abate the writ until August 10th, and on that date, we'll see if there is an information filed or an indictment, and then if so, then we'll proceed with the plea that day. If something falls through the cracks between now and then Mr. Manning, you just alert me along with the state, and we can have a hearing more quickly on the writ if need be.
Yes, Judge.
Okay, so August 10th, worst case.
Do we have anyone else that's ready, Mr. Abraham?
I wanted to ask you 2 questions.
Okay, go ahead.
Okay, on Mr. Fratter had filed motion for continuances on that Shane Adobe. So I didn't know whether you wanted us to bring her up. They were e-filed.
I don't know. Are they in my queue? When were they e-filed? Do you know?
It's been maybe a day or 2. She's on the bottom of page 9 and the top of page 10.
Let me look.
I thought the most recent from him was that he could be, that someone else who was co-counsel on the case could be here.
Okay, well, there's not. Okay.
I'll look through my emails and see.
I believe that, I do recall that, I believe.
Oh, Your Honor,
Yes.
so my email from Mr. Fratter is, I just got word from co-counsel Mike Stevens, he can be there on 6/29.
Oh, let me look here. I'm reading this motion too. All right, so you said that Mr. Fratter or co-counsel could be here on Thursday?
Yes, Your Honor.
Okay, let's just do that. No, you can send word to Miss Dobie that we're gonna call her back up on Tuesday at 1:30, and the court will grant Mr. Fratter's motion for continuance.
On Thursday.
And I'm just gonna carry it to Thursday, yes.
All right, the other one, Ryan Augustine is, we had status of Dallas County, but now he is in TDC in the veto unit. I guess we need to see if Ms. Curry is wanting us to bench warrant him. He's on page 8 and on page 11. Mr. Smith represents him on one of them, the assault, ag assault.
If I recall, the ag assault is one that is a revocation, I think, and I am gonna want him.
I don't think so. I was retained on the ag assault. I don't recall, we never pled him, but I do know that I was dealing with Ms. Heisel. And we came to the conclusion that we were going to do something on injury to the elderly because of the age. It alleged serious bodily injury. And the other charge was picked up later, but he was shipped off to, I think Dallas County on a revocation or something like that. That didn't have anything to do with ours. So we've got 2 open offenses that have to be resolved.
Okay, and the other one is a theft, I believe.
Yes.
Yes, Ms. Taberham, we'd like him benched.
All right, let's set him for August 22nd. That'll give us some time to get the bench warrant to the sheriff's office and give them time to plan for that.
All right, are you ready? Okay, Mr. Smith is back ready.
All right, who are you ready on now?
Andre Davis.
Andre Davis, CR 23-27, set for pretrial. Go ahead, Mr. Schmidt.
Judge, at this point, we don't have any contested pretrial motions. I do know that the state has made an offer to my client, which he wishes to accept as quickly as possible for for TDC. He was hoping, and I was hoping that if at all possible, we could set him for Thursday to do that plea.
I thought you slept in all day on Thursdays. So not
Unfortunately, this Thursday, I was mistreated by the court, and I've already got lots of so.
well, since let me right my wrong then. We'll set Mr. Davis for plea on Thursday.
Thanks, sir.
I'll atone for my sin.
It's because it's evidentiary.
Jeremy, come on down.
Mr. Hester.
Correct.
Jeremy Wayne Hester, CR 21-291, docket call.
Judge, we're gonna ask for an additional docket call. I've been having discussions with Ms. Curry about some potential information that we'd like to share with today involving Mr. Hester's case, and I think we're going to attempt to set up a meeting with Mr. Hester, myself, and some other individuals as soon as possible. So at this point, we'd ask for an additional docket call, to try to accomplish that.
All right.
That's correct, Your Honor.
All right, court will then reset Mr. Hester for a final docket call on August 8th. And that'll be at 1:30. Who do you have, Mr. Schmidt?
This is Kobe here.
Kobe here in CR 23-98. This is arraignment
That's
on
correct.
engaging in organized criminal activity. Go ahead, Mr. Schmidt.
Yes, sir. Received a copy of the indictment. Mr. Heron's name spelled correctly, understands what he's charged with. Today, we'll waive formal reading, enter plea not guilty, ask for a pretrial set.
All right, court will enter Mr. Heron's plea of not guilty into the record. We'll set this matter for pretrial hearing. Is August 8th okay, Mr. Schmidt, or do you need longer?
I think on this one, like I say, it'd be great.
Okay, August 8th it is at 1:30.
You're not ready. Okay, Your Honor, it looks like we need a few minutes.
Okay, thank you. Hey, check your phone before we come back.
Okay.
Mr. Knoll, are you ready? Are you ready on Mr. Chumley?
Did we're ready to say that I have two plea offers. One of them is probation with safety, the other is some time to do. I have gotten a number of days credit, which is substantial. Mr. Chumley, who is obviously here, wants some time to make that decision. I think, and we just need to be on a plea docket so that he can either take one or the other. And I think July the 6th is the earliest.
That's correct. You want me to reset to July 6th?
That would be correct, Judge, if we can.
All right, so do you want me to set it for status on plea?
Correct. It'll be one or the other. We should have papers done before then.
Okay. All right, we'll see Mr. Chumley back on July 6th. That'll be at 1:30, so long as he's in custody.
Thank you, Judge.
You're welcome. Mr. Shea, you ready?
Yes, sir, I'm ready.
Who are you ready on?
This is Warren Clay Pruitt.
Mr. Pruitt? Let me flip over here. All right, Warren Clay Pruitt, CR 22-45. I show that we are on competency reevaluation status on that.
That's taken place, Judge, and he's been deemed competent. I agree with the new finding. We're ready to, I think, arraign Mr. Pruitt and get him on track to resolve these cases.
All right. Do you have the indictment or can I display that for you?
You can go ahead and display it, Judge, if you don't mind.
Sure. Yeah, give me just 1 second.
That makes sense. We're gonna get you past the main part first.
Can you see that, Mr. Schmidt?
Yes, sir. So your stance. Yes. Not. Good, we're ready to proceed with arraignment. Mr. Pruitt's name is spelled out correctly in the state's indictment. He understands his charge. We waive formal reading, enter a plea of not guilty in totality and ask that it be set for a pretrial.
All right, court will enter Mr. Pruitt's plea of not guilty into the record. Court will set Mr. Pruitt for pretrial hearing. You want the 8th or the 22nd, Mr. Schmidt?
22nd, please.
All right, court sets Mr. Pruitt for pretrial hearing August 22nd at 1:30.
So we come back on this case, some of it, but that does not preclude me from trying to get you. And down in the right same page. Well, if you were able to, something can be done tomorrow. Get her done as quick as you can. Thank you.
Who else should we go?
Preston Wilson.
All right, this is cause number CR 23-83. Mr. Wilson is set for pretrial. Go ahead, Mr. Schmidt.
Judge, I'm going to ask for an additional pretrial setting for Mr. Wilson. I have not had an opportunity to go over discovery with Mr. Wilson, which I think is critical in this case. A short reset for an additional pretrial is what we're requesting.
Any objection by the state? Hearing none, the court will set Mr. Wilson for an additional pretrial August 8th at 1:30.
Sorry. I said it, you know, video together with the- Okay, cool. You got to do a follow up on those objections, put your information out. Yeah. We'll put all of that, yeah. Come on down here, you're good.
All right, is this Mr. Powell?
Yeah, Judge.
All right, Gerald Wayne Powell, CR 21-235, status on Dr. Proctor's reports.
And Judge, Dr. Proctor and the state Dr. Proctor has finished his report, supplied to the state. State has given me a copy of it. I'm in the process of reviewing it and going through the general conclusions. Ultimately, at this point in time, we have our own independent forensic psychologist to do our own evaluation. The court has provided us with funds for that previously. I would note for the court's attention that I'm going to seek, or I'm trying to seek, the help of a forensic psychologist other than the one I previously selected. And I've got some names from the state and some independent examiners. So at this point in time, the state has completed their portion of it. Now we're going to move on to our part of it.
Okay. All right, so we can set this for what?
I'd say 90 days would be not even conservative, but 90 days would be reasonable. Mr. Powell's aware of the process, and we understand that he understands at least that it's taken a long time to get these things done because of independent experts. But I would suggest that, you know, if I cannot locate a different expert that's qualified to handle these matters, then I will move forward with the one I have. But I want to make sure we're not double dipping on the court's funds and get a one-stop deal. So I will tie that down this week. If we get 90 days, I would like to believe it wouldn't take nearly as long as it took on the prior examination. But that one took, I believe, 8 or 9 months.
Okay, we'll set Mr. Powell then for September 26th. We'll say status on defendant's expert. Any concerns by the state at all on the court setting it those 90 days?
None, Your Honor.
Okay. All right, so that'd be September 26th at 1:30.
We have no house. They got low and John Boy.
I know, but they're waiting.
Be
Your
ready.
Honor, we're fixing to do the two writs that Mr. Schmidt has. Then we'll get the two females and then Mr. Gerard. Then that should finish us up.
Okay, sounds good.
Oh, and Mr. Reeves' plea, but we're waiting on paperwork.
Okay, sounds good.
Says you have another recording.
Judge.
Yeah.
Your Honor,
Yes, ma'am.
okay, we're ready with Mr. Lowe and Mr. Gerard.
Afternoon, Your Honor.
Good afternoon, Mr. Lowe. Good afternoon, Mr. Gerard. All right, Mr. Lowe, let's see. Go over here to that. Sorry, I'm not already there. All right, I think that this is just a status on Mr. Gerard and his placement on the list. You have any updates for the court, Mr. Lowe? Go ahead.
No, Your Honor, I think that the information I received is that he's taking his medication. He's not been a problem.
But he has filed a motion to have me terminated as his lawyer. And so I think he wants to present that motion, Your Honor. That's okay with you.
Sure, I'm willing to listen.
Go ahead.
Go ahead, Robert.
Well, I wasn't, I was supposed to have court on the 22nd. I didn't get there until today. He had to come see me before court most of the time. And then there's I couldn't get my motion for discovery. I don't get why I don't get my motion for discovery, because there's some things I wanted to look at in there.
Okay, Mr. Lowe, do you want to respond to that at all?
Yes, Your Honor. He's correct. I haven't seen him. Since he filed the motion to terminate my representation. I think our dispute, though, and it's not really a dispute, is that he wants to see complete copy of all the discovery. And where he is, Your Honor, I've told him there are restrictions on that. So I started reading him all the discovery, and I don't think he felt that was good enough. So sorry. So I think that's, and I'm not gonna just turn to him a copy of the complete file in the situation where he is now, Your Honor. I can comply with the discovery rules, but I think where he is, I wouldn't feel comfortable doing it unless the court said it was okay. To give him a complete copy of all the discovery.
And what you're indicating, just so I'm clear, Mr. Lowe, is you're saying that you don't want to make a physical copy of the discovery and leave it with him in the jail.
That's correct, Your Honor.
But you are not opposed to showing him copies of the report and the discovery there at the jail.
You know, of course, the situation is we have to pass it through the little slip. So, but he may have other issues with me, but that's what his concern or main concern was, is not being able to see the actual documents that were gotten. Of course, there are pictures, there are witness statements, things like that. And I really don't, unless you told me it was okay, I wouldn't want to give him a hard copy.
And so Mr. Lowe is correct, Your Honor, as I'm sure the court knows. The current law now is that Mr. Lowe is prohibited from providing a copy to the defendant. He can read it to him, he can show it to him through the glass, but he is prohibited from giving it to him.
That's correct. Mr. Gerard, do you understand that?
I understand.
And so, but Mr. Lowe, I would let you know that if you need to have a consultation with your client to where you're not having to try to explain the discovery between the glass, I believe that you can contact the sheriff's office and be able to get, back there where you're at in the law library or something like that for an opportunity to show him, the physical documents, and if he wants to read it for himself and those things, that can be accomplished. But you'll have to contact the sheriff's office to make those arrangements.
All right.
And that may satisfy Mr. Gerard on a couple of those issues.
But as far as I'm not to deliver him a copy for him to have in his cell.
That's correct.
And other than that, Your Honor, I don't think we're at the point where he has a restoration of competency. I think we're still a ways from there. So if you want to set it for a status in August, I'll come between now and then. I'll come. We'll go over the discovery that I have with him, and so he has satisfied about that.
Okay.
But I don't think we're ready to say he's restored.
Well, and he would have to be reevaluated too by the doctor before we would say that. I'm not just going to have an agreement that he's restored without him, seeing a professional. But let me address that, Mr. Gerard. So you are taking your medications there at the jail that have been prescribed by Dr. Corman?
Yes, sir.
Okay, and you are presenting much better today. You seem to have more ability to listen and be rational. Or do you think the medications are helping you have a better ability to do that?
I guess, I don't know.
Okay. All right, well, Mr. Lowe said that he thinks that you're in a better state. You appear to be in a better state to me. So I would just encourage you to continue to rely on Dr. Corman and his diagnosis and the medications. If at any time you think the medications are presenting you physical ailments or issues, then you let us know and we'll get that adjusted or changed, okay? Okay, so at this time, I'm going to deny Mr. Gerard's request to remove Mr. Lowe as his court-appointed attorney. We will reset Mr. Gerard. My notation is that Mr. Gerard is number 818 for a bed at the unit in which he would have to go based a maximum security unit. So we're going to monitor that. If, as you said, Mr. Lowe, if you think that Mr. Gerard continues to progress to the point that you think that he may meet the standards of legal competency, then you can always notify the court and the state. And what I can do is I can ask that Mr. Gerard be re-evaluated. And if that changes the opinion of the psychiatrist, then or psychologist, then we can, move him to a different stage in the litigation. We can put him back on docket call or pre-trial and deal with those. So if not, then we'll just continue to wait for hospitalization.
Yes, sir.
Okay, so I'm going to reset it, and I'm going to reset it. Today is the 27th. Let's set it in September. Do you have your calendar available, Mr. Lowe?
I do, I don't have anything that far out, though, pretty sure.
Okay, then let's go September 19th for status.
Okay.
And if anything, in your checking with Mr. Gerard between now and then, if any issues arise, then you let the court know, and we can always get a hearing sooner rather than later.
Yes, Your Honor. I think we're good, Your Honor.
Okay, all right, Mr. Gerard, I'm glad to see that you're doing better. We'll see you soon. And Mr. Lowe is going to work with you on showing you that discovery, okay? Thank you, Mr. Lowe. Thank you, Ms. Curry. Mr. Schmidt, who are you ready on?
Kindle Jean Harrington Dotson.
Dotson? All right, this is Writ WR 23-47, Kindle Dotson. And are you calling your client today at all, or is there an agreement?
I haven't spoken with Ms. Curry. Probably should have, but I'll probably have to call my client real quick.
Okay. All right. If you'll raise your right hand, I'm going to place you under oath. Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
All right. Thank you. You can lower your hand. Go ahead, Mr. Schmidt.
Mr. Dotson, we filed a writ seeking bond reduction or PR bond on 3 charges: burglary of habitation, and theft. Is that correct? Yes, sir. And you were arrested on those offense March 17th, 2023? Yes, sir. And that's been over 9 days. Are you indicted on any of those cases? Sir. Cumulatively, your bond set at $70,000. Is that correct? Yes, sir. And through myself and your mother and other family members, we've attempted to secure a bondman to bond you out pending trial on these charges. Yes, sir. And you've been unable to do that. Is that correct? Correct. Ultimately, you have an indicted case in this county and your bond set at $20,000. Is that? That's correct. But that's not before the court today. We're here on the unindicted charges where you're seeking a PR bond on those, correct? Correct. And ultimately, you would be required to post a surety bond on the other case. And you've been in contact with folks and bondsmen and believe that you can do that. Yes, sir. if you bond out of jail, you'll be required to make all your court appearances as ordered. Do you understand that? Yes, sir. And are you able to do that if you're out? Yes, sir. I will. Do you have a job lined up? I have 2 of them. Okay, so you'll be able to work and pay your pretrial supervision fees, et cetera. Yes, sir. Where do you live normally? In Kent, Texas. Who do you live with? My mother. And it's in Stykes, actually. Okay, and what's your mother's name? Stacy Witherspoon. And Miss Witherspoon is the one that I've been speaking to about your bonds, correct? Correct. And do you have any other matters pending in any county other than those that county? No. So these are the only things that you're being held on at this point in time? Yes, sir. I'll pass the witness.
State, any questions?
Yes, Your Honor. Mr. Dotson, how many times have you been to TDC?
I've been twice and I've been to a safety.
So the charges that you're facing are 25 to life charges. Were you aware of that?
No, ma'am.
Do you agree that with 2 prior pen trips to TDC that it's a 25 to life?
No.
So you didn't know that's what you were, that's the punishment range you were facing?
No, ma'am.
And you are indicted on a evading in a vehicle, is that correct?
No, ma'am. There was no vehicle.
I'm sorry, was it evading with a prior?
There may be a prior years ago.
Judge, I'm going to object. She's asking him to speculate on an actual legal conclusion. It's the state's indictment. We're not prepared to give evidence to substantiate an enhancement or required matter of proof we're on bond matters. If the state wishes the court to take judicial notice of the state's indictment, that's fine, but obviously we pled not guilty to that. So I would object to asking for a legal conclusion from the defendant. I also object to relevance. It is what it is.
Court will sustain the objection as to a legal interpretation. Court will overrule the objection as to relevance. Court finds that criminal history is relevant in determining the Article 1715 in bail reduction. Go ahead, Ms. Curry.
Thank you, Your Honor. You were previously arrested also for the offense of escape, is that correct?
I was pepper sprayed in the back of a cop car. Yes, and that's from
And
custody.
what was the sentence you received for escape?
It's been 20 years ago. I don't know what I think it got dropped down. It was I don't know what it is.
You were sentenced to 10 years for aggravated robbery, correct?
Yes, ma'am. I know it don't look good. Sorry.
You've also been convicted of aggravated assault with a deadly weapon
Yes.
and evading arrest with a vehicle, is that correct?
Yes, ma'am.
When's the most recent time you got out of prison?
2020 was a safety.
And you got off parole in 2022, is that correct?
Yes, ma'am. I completed it.
Well, except for going to safety.
I went to safety and completed it. Yes, ma'am.
If you got out of jail, where would you be living?
With my mother in Stykes. It's in Counsel.
I'll pass the witness, Judge.
I'm sorry, you cut out for just a second. Say that again, Ms. Curry.
I'll pass the witness.
Okay, Mr. Schmidt, any follow-up?
No follow-up. We're resting.
Okay. Anything from the state?
No witnesses, Your Honor.
Okay, Mr. Schmidt, would you like argument?
Well, Judge, we've got charges pending, bail set. There is no indictment from the state. It's post 90. 17-151 is pretty clear. There are provisions in which that doesn't apply. 17-151 section 2. However, I don't believe that under the circumstances with an indicted charge, an argument can be made that that doesn't apply and that he's entitled to PR bonds on the unindicted charges. Obviously, he will be held over posting a surety bond on an indicted charge with this county in the same jurisdiction. So we're asking the court to grant PR bonds on unindicted charges, and then that will free him up to either post a surety where he'll have to answer to a bondsman if he can do so, and if not, we'd have to come back to court on that. But at this point in time, the state doesn't have a case. They're not ready for trial. We'd ask the court to grant those PRs on those 3 charges.
Thank you, Mr. Schmidt. Ms. Curry?
Your Honor, I disagree with Mr. Schmidt with regard to whether or not 17-151 is applicable here. It's the state's position that it is not applicable. However, in this particular case, we will agree to the PR bonds on those cases because of concerns I have about the strength of those cases and whether they will ever be prosecutable. So I feel like the right thing to do is not to hold the defendant to a bond on those.
Okay, all right, the court will then grant the request for a personal bond for the burglary of habitation in the amount of $30,000 personal bonds, and on the theft of property, $10,000 personal bond. Court's gonna have conditions of pretrial release. If there's not already some in the case, the court is going to order pretrial release conditions to stay away from the alleged victims in each one of the causes, in addition to the other standard conditions of pretrial release. Court will order that Mr. Dotson sign those conditions of pretrial release before posting any personal bond in these matters.
Thank you.
Yeah, that's great.
Your Honor,
Yes, ma'am.
we're ready on the plea on Mr. Jeremy Reeves.
Get so far my head this years.
I know, y'all taller gentlemen.
That's that right here.
All right, and I don't think I have the paperwork over here on the plea. So, Mr. Davis, what I'm going to ask you to do is read me the terms of the plea agreement.
We'll do that, Your Honor. Your Honor, this is cause number CR 21-00187, a 1-count indictment where Mr. Reeves was placed on community supervision on a deferred status. The state has moved to, and we have agreed that his community supervision be revoked. The original charge was assault on a peace officer from November 8, 2020, which was a second-degree felony. He is being sentenced to 5 years in the Texas Department of Criminal Justice Institution Division. The date that sentence is to commence is beginning today. There's a $2,500 unresolved fine from his probation, $410 court costs. In addition to that, Your Honor, he has 426 days back time credits. There's also on this finding that there was no deadly weapon alleged in this indictment, or was one found. And upon his plea of true to the allegations as set out in the motion to revoke, we're asking that the court follow that agreement.
All right, and what about with regards to the driving while intoxicated charge?
That one, Your Honor, is being withdrawn. That motion to revoke is being withdrawn. It's being allowed to just terminate.
Withdraw and terminate, or withdraw and leave him on probation while he's in prison and naturally terminate? Is that what you're saying?
This paper says motion to withdraw states, motion to revoke and terminate community supervision.
Okay, withdraw and terminate today.
Yes, Your Honor.
Yes, Your Honor.
Okay.
And I'm prepared to read the counts as to the allegations of his failure to.
That's okay. That's okay. You've done a good job. Let me take over for you right here. Can you gentlemen see that? Okay.
Yes, Your Honor.
All right. And so, Mr. Davis, does your client intend to waive the formal reading of the state's motion to adjudicate?
He does, Your Honor.
And does he intend to plead true to what appears to be all 7 counts alleged in this motion?
He does, Your Honor.
Okay. Mr. Reeves, sir, if you'll raise your right hand, I'm going to place you under oath. Mr. Reeves, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Sir.
All right, you can lower your hand. All right, Mr. Reeves, you did appear before the court on January 6, 2022, pled guilty to the 2nd-degree felony offense of assault of a peace officer or judge. The court heard the evidence that day, followed the plea agreement that you reached with the state. The court deferred a finding of guilt, placed you on 2 years community supervision, and also ordered a $2,500 fine. Court finds that on April 28th of 2022, the state filed its motion to adjudicate and to revoke your community supervision. And they have alleged in this motion 7 separate counts of various ways they are alleging failures to comply. Do you feel like you've had enough time to discuss this motion with your attorney, Mr. Davis?
Yes, sir. Yes, sir.
Okay. And do you understand everything that you've read and signed today?
Yes, sir, I do.
All right. Mr. Davis, do you believe that Mr. Reeves is entering into this agreement intentionally, knowingly, and voluntarily, and that he's incompetent, and that he is in fact competent in doing so?
Yes, Your Honor.
All right. All right, then, Mr. Reeves, understanding the allegations, the court finds that you have waived the formal reading of the state's motion to adjudicate. This time I'd ask you, how do you plead to the counts alleged in 1 through 7? Are those counts true or not true?
True.
And are you telling me that those counts are true because in fact, what is alleged is true? You're not just saying that to get a certain plea agreement?
Yes, sir, they're true.
All right. And Mr. Reeves, has anyone threatened you, forced you, pressured you to plead true to any of these counts?
No, sir.
All right. Court will accept the defendant's plea of true to each count alleged in the state's motion to adjudicate and revoke. Mr. Davis, any objection to the admission of the defendant's waiver of rights to plea of true in evidence?
No, Your Honor.
That's admitted, and the court takes judicial notice of Mr. Reeves' judicial confession. Anything further from the state?
No, Your Honor.
Anything further from the defense?
Your Honor, I did not have him mark on the notice of appeal anything. I thought the court would probably do that, but he is waiving all rights to appeal in this case. And it's my understanding, the DA can correct me if I'm wrong, or the court can correct me wrong, but on deadly weapon findings, I believe they have a none rather than NA, but whatever the court is pleased to, and then I think it actually, I had to say none rather than an NA, but whatever pleases the court, and at that we would rest.
Okay, and you're talking about the original offense, the original judgment. Let me see if I can pull it up here.
Yeah, on this, yes, on judgment adjudicating guilt. There was no allegation of a weapon, and
Yeah, the original order deferred said findings on deadly weapon not applicable. And so are you saying that the order there says not applicable as well?
It does, Judge.
Okay, I think that's sufficient then.
Okay.
All right.
The defendant rest.
All right, then, based on the evidence presented to the court finds that Mr. Jeremy Alexander Reeves has violated the terms and conditions of his community supervision. Court will follow the plea agreement today. The court hereby revokes his community supervision, assesses punishment at 5 years confinement in the Texas Department of Criminal Justice, orders him to pay the balance of his financial obligations originally imposed, and the court will award Mr. Reeves 426 days credit towards his sentence for the time that he has already spent in jail on this cause. That's with regards to CR 21-187. With regards to CR 21-154, the driving while intoxicated, the court grants the state's motion to withdraw and terminate community supervision. So, Mr. Reeves, I'll need you to step over with the deputy to be fingerprinted. Good luck to you, sir.
Thank you.
Thank you, Mr. Davis. I appreciate your help.
Thank you, Your Honor.
You're welcome. Patty, are you having a hard time hearing me at all?
No, sir.
So my microphone is out here in the courtroom, so, but you're picking me up okay?
Yes, sir.
Okay,
Okay, on Nicole Pentler. She had not completed her affidavit. She believed that she still had Mr. Stevens. She has a new motion to revoke. She has completed her paperwork this afternoon here at the jail, and she does qualify. I was going to appoint the Honorable Richard Smith.
did Mr. Stevens have her originally, you said?
Just a second, Your Honor.
I started as a counsel. And then Mr. Stevens replaced.
Okay, I'm sorry, Your Honor.
What are you sorry for?
Mr. Smith, reminded me, I've lost you,
No, I'm still here.
reminded me that he had a conflict. So I will need to appoint the Honorable Mr. Manning.
Do you want to inquire with Mr. Stevens, since he's familiar with her, if he wants to take the motion to revoke case first, and then if not, then Mr. Manning?
Yes, sir. What degree? I didn't see what the degree was. It's a
I think
second.
it was a second burglary of a habitation, but I think the characterization, it being a motion to revoke, may change things
Okay,
for Mr.
yes, sir. We will ask and then we will get back with you on either Mr. Stevens, who your attorney's gonna be.
So, Ms. Pentler, what I'm gonna do is I'm gonna reset you today. I'm gonna reset you for the contested hearing docket on July 25th. And then in the meantime, we'll either appoint Mr. Stevens and he'll come see you. If not, then Mr. Jonathan Manning and he'll come see you. And they'll have time to talk with you about the case.
Okay. Hey, Your Honor, I think we're down to two more. Three?
Yeah. Where is that? Yes. Great.
We still have Nikisha Devlin, Jamie Nash, Robert Hodgkins, I believe. Are those the three?
Yes, sir. And they're
Okay. Do you need time, Mr. Schmidt?
No, sir, ready to rock. We can do Robert Hodgson first.
Okay, Mr. Hodgson, if you'll come up. All right, and this is a writ, is that correct?
It is, Judge, and I believe we have an agreement with the state on our request.
All right, what's that agreement?
Judge, the charges pending in Van Zandt County, they're enumerated in my writ. I believe they're all unindicted. We're asking that the court grant Mr. Hodgson a PR bond on those cases. He will be transferred out to Smith County on an indicted case to handle that one, but the state's in agreement. Of course, she can speak for herself.
Yes, the state agrees, Your Honor.
All right, and what's the agreement on personal bond amounts? Does it matter?
Not to me, Judge.
No, Your Honor.
Okay, all right, the court will grant the writ of habeas corpus. Court will set personal bonds of $10,000 in each case. Court will sign conditions of pretrial release if not already imposed. And Mr. Hodgson will have to sign those before he's being released from custody.
Sir. They'll bring you those orders later. Great.
All right, who do you have now?
This is Jamie Nash. Judge, we were set for a plea. Somehow we got lost in the shuffle. We're asking that it be set for Thursday. Give us time to get the papers together and get her pled out.
All right, court grants that request. We'll set Ms. Nash for plea on Thursday at 1:30.
Thank you.
You're welcome.
Going on YouTube, that looks stupid. I don't know what day it is. Here you go. Thursday. Come on down and get you.
Ms. Devlin, CR 23-47.
Judge, we're here on competency status where Ms. Devlin was previously deemed incompetent to stand trial. She's been treated while in Van Zandt County Jail. I've had a couple of conversations with her. I'm competent to say that I believe she's competent to stand trial at this point. We'd like to address the competency issues as quickly as possible. We have an agreement with the state, which Ms. Devlin wishes to accept. Now that she can communicate and she knows what's going on, we're on the same page. So normally I would ask that a competency reevaluation take place. If there were a way for us to fast track that so that we could be in the position to plea her out on Thursday, that'd be great. Procedurally, I'm sure a board certified attorney like Ms. Curry would know better than me. But that's our goal, and I think she's doing really well.
Okay, best I can do is, because we do have an order finding or a finding of incompetency and an order on that, is I can set her, I can't set her on Thursday. I could try to set her for middle, well, you're gonna be out, you'll be out July, so Dr. Ingram's gonna need to come and reevaluate her, and I don't know what his schedule is. I don't know that he could be here tomorrow to do that and then produce a report. There's just no way to know that, so.
Understand.
Best I can do is set you for August 8th and then ask Dr. Ingram to the sooner the better. And then if you're available on July 25th for the evidentiary docket, I could probably bump it up a week or two.
Sounds like a good plan. Thank you.
Okay. All right. We'll set Miss Devlin then for status on competency and or reevaluation for August 8th. And we'll get that order to Dr. Ingram today.
Thank you, sir.
You're welcome.
Does that make sense?
I believe that concludes our business.
Does that conclude our business, Ms. Abraham?
I believe.
Thank you.
All right. Appreciate everyone's help at the jail today. And us concluding the afternoon docket, we will be adjourned for the day.
Okay, we'll see you in a few minutes.
Thank you.